we have a couple of questions that I'm going to toss at least one out to Reno. The question is, why can schools search phones since the phones are not school property?
Thank you, Judge Higgins is going to respond to that question for us.
Well, I've signed several search warrants in these kind of cases for sexting matters. I had a middle school student who was talking young ladies into going into the bathroom and taking pictures in the mirror with his phone that he distributed to everybody, and the principal found out about it. There's several issues that happen, overlap here. One young man asked about privacy, and I think more than one internet commentator said we need to get over the idea of privacy in the internet age. This is not a photo from a Polaroid you're handing to somebody. You take this photo, it goes to a cell tower, it goes to an email service, it's on a cache on a hard drive somewhere, it gets aggregated, it gets sent back. As soon as you've done that, you've broadcast this photo to the entire world. It's just not going to who you send it to, because as soon as they get it, they can send it to somebody else. So the idea that these are private photos is a misnomer. They're not. The second thing is it's evidence of a crime, and for these to be searched, there has to be probable cause to issue a search warrant. And I've done that, and that search warrant not only includes the phones, also includes the internet service providers. So if they've cached these photos, even if the recipient and the sender have deleted them, they still could be online at the internet company. And so those photos are just floating out there in cyberspace and they don't go away. And then where they end up, and they probably don't understand it, they end up on adult websites where people pay to see them, and they get aggregated, and they're all over the world. And in prosecutions, these photos turn up everywhere. So the idea that it's a private photo it's not. As soon as you send it, it's open to the entire world. And our Supreme Court has commented that part of the prosecution and the purpose of the child pornography laws is not to create a market for this. So even if the person taking it and the person receiving it are juveniles, by allowing it to be published, you create a market where other people can use it, and you allow this to become part of our society where this is okay, and it's not okay. And so there's a lot of reasons why these pictures aren't okay and why phones get searched. And our Supreme Court's also said that juveniles don't have the full array of First Amendment rights. They don't get to say or do anything they want. Adults have a responsibility to control that.
We have some comments waiting here in Las Vegas, but I understand also that Judge Spool and Chief Justice Perigary have some comments in Carson. Chief?
I believe Judge Spool wanted to make a comment a little bit earlier.
Well, I'll make it brief, just to say that the point has already been covered perhaps, and that is I see people in court almost on a daily basis on a simple marijuana possession charge, for example, and I frequently say to them, I don't really care what you think about marijuana use. It happens to be against the law, and there are consequences. And when it comes to this area of sexting, I think even more alarmingly, perhaps, as Judge Higgins is pointing out, we ask our teenagers, and by the way, this law is not limited to teenagers. It applies to anybody of any age, and I think we should bear that in mind. I'm looking at it right in front of me here. But the emotional and physical consequences for a lifetime of sexting to a victim as well as the perpetrator, for example, are so consequential that we just ask the younger people to take it on a bit of faith. And if they don't take it on a bit of faith that we know something that's better for them, then I fall back to the bromide that I use in court every day. Well, it's against the law, and that's reason enough. Thank you.
Ms. Brown, I believe that you wished to comment perhaps on one of the earlier questions.
I did. I wanted to respond briefly to the thoughts shared by Ms. Roski. First, I wanted to note that we agree in the vast majority of cases what is an appropriate handling of these cases. Second, I wanted to note that the state of Nevada did amend Chapter 62 a couple of years back to remove registration. Child pornography committed by juveniles is a registration offense. So unless those children are certified to the adult system, those children will not end up on our sex offender registry. So I just wanted to put that thought to rest. I also wanted to note that the cases to which she's referring, the Clark County District Attorney's Office has never certified a sexting case. she's talking about. I do not want to go into detail in light of the audience that we're discussing, but they are graphic and numerous child sexual abuse images. And so I did want to just make clear that we are not seeking certification of children for sexting.
The comment made by one of our two school representatives about leaving a phone out at lunch has caused some activity on our feeds. And the question posed is, quote, so leaving a phone out at lunch counts as probable cause. And we've got a couple of different concepts here. There's a standard of probable cause in the law. There's a different standard at the schools. I'm going to toss this out to anyone on the panels who can indicate to me in some manner that they wish to respond to that question. The question really is, does leaving my phone out at lunch count as probable cause to allow you all to take a look at what is on my phone? Apparently, Mr. West from Green Valley High School will respond first.
Well, I just, after seeing many kids with many tears when they lose their phone for whatever reason, our number one thing is to look at the phone to try and find out who the owner of the phone is and to return it to them. Sometimes that includes just looking up mom in their contact list and making a few phone calls and figuring out who it is. Sometimes it's not that easy, and you have to, sometimes there's locks on the phone, they have a security code on their phone, and it's not quite as easy, so we have to be a little more careful. But the reality is that the phone, students, for example, don't have a right to privacy with their locker. They don't, if it's a left phone, if it's a phone that's sitting out in school, absolutely we have a right to know and be concerned about what could be in that phone and why it was left. Maybe it was accidental, maybe it wasn't. And we always, with a school that has 3,000 students, we err on the side of safety all the time. And I believe that the law is on our side with that.